Ever wonder how many rule books a single country actually needs just so a couple can tie the knot? In most places around the world, the answer is pretty simple, just one. But if you're looking in India, the reality is entirely different. We aren't talking about a single rule book here, we're talking about an entire library. Because of its massive cultural and religious diversity, India has built this totally unique legal structure where the laws governing your marriage often depend entirely on your faith, your community, and your own personal choices.
Welcome to The Explainer. Today, we're diving straight into India's matrimonial mosaic, from custom to constitution. Think of the Indian legal system like a giant, beautifully intricate mosaic. When you look at it up close, you see all these individual tiles representing distinct religious traditions and customs. But when you step back and look at the whole picture, you start to see exactly how these unique tiles are held together by the overarching framework of the Indian Constitution.
Here is our roadmap for today. 1. Religious marriage frameworks. 2. Secular and foreign marriages. 3. Comparing India's marriage laws. And 4. Beyond traditional marriage. Let's get right into it.
Section 1. Religious marriage frameworks, protecting community identity. So the core idea here? Protecting community identity. The legal system recognizes that for a lot of people, marriage isn't just some standard civil contract, it's a deeply religious tradition. Take the Parsi Marriage and Divorce Act of 1936 as our first case study. For a marriage to be legally valid under this act, both parties absolutely must be Parsis, and they can't fall within prohibited degrees of relationship. But it actually goes way beyond just demographics. The law literally mandates the religious ritual itself. It explicitly requires the Ashirvad ceremony to be performed by a Parsi priest right there in the presence of two witnesses. By writing these specific requirements into the law, the state actively preserves the unique customs of the Parsi community while still giving them a formal legal structure.
Now, even with all these different rituals across communities, there is a really fascinating common thread: 21 and 18. This is the statutory age requirement across multiple different acts. The groom has to be at least 21 years old, and the bride must be at least 18. This is a crucial intersection where state policy meets religious custom to lay down a universal baseline for maturity and consent.
All right, let's switch gears to the Indian Christian Marriage Act of 1872 to see how this builds in a different context. This act governs unions where at least one party is Christian, and we see a different set of foundational rules here. Under this framework, monogamy is absolutely mandatory. Neither party can have a living spouse, period. The law also puts a massive emphasis on free and voluntary consent, requiring that both parties be mentally competent. And much like we saw with the Parsi Act, the solemnization involves specific figures, like a minister of religion, a licensed person, or a marriage registrar. It's a carefully designed system balancing religious tradition with modern principles of equality.
But what happens when things go wrong? These acts have to deal with that too, and it brilliantly illustrates the nuance in the law. Let's look at nullity versus judicial separation. Nullity is a legal declaration that the marriage was void from the very beginning. Maybe the parties were too closely related, maybe there was fraud, or essential conditions like consent were totally absent. Legally speaking, the marriage never even existed. Judicial separation, on the other hand, is basically a legal pause button. Spouses are allowed to live separately without actually dissolving the marriage itself. It gives them a legal remedy while leaving the door open for reconciliation down the road.
Section 2. Secular and foreign marriages. The path of personal choice.
So, what if you want to step outside those religious frameworks entirely? We're now shifting our focus to the path of personal choice. Enter the Special Marriage Act of 1954. The biggest takeaway here is that this is a completely secular, religion-neutral framework. It was designed specifically to promote national integration, letting people of different faiths marry without anyone having to convert or renounce their religion. It is the definitive legal avenue in India for interfaith and purely civil marriages, putting freedom of choice right above religious mandate.
But how does that actually play out? Because it bypasses the religious ritual, the Special Marriage Act relies on a very clear, bureaucratic journey. Step 1, you give a formal notice of intended marriage to a marriage officer. Step 2, that notice is publicly displayed for a set period to invite any legal objections, like say if someone claims one of the parties is already married. Step 3, if there are no valid objections, the marriage is solemnized before the officer and 3 witnesses. And finally, Step 4, a certificate is entered into the official register as absolute proof of the union. You're basically swapping out the priest for the state and the ritual for registration.
You really can't overstate how important this secular path is. In the landmark case of Lata Singh versus State of Uttar Pradesh, the Supreme Court firmly upheld the freedom of adults to marry a person of their own choice. This act isn't just some administrative paperwork. It's a profound legal shield that protects individual liberty against societal or familial pressures. And guess what? This secular philosophy even extends across borders. The Foreign Marriage Act of 1969 gives Indian citizens a legal mechanism to get married outside of India. It functions a lot like the Special Marriage Act, allowing couples to solemnize their marriage before a marriage officer in a foreign country, which ensures their union is fully valid and recognized back home.
Section 3. Comparing India's marriage laws, a constitutional tapestry.
Now that we've examined the individual pieces, let's zoom out for a second and look at this whole legal tapestry side by side. Just look at the origins. Hindu law traditionally views marriage as sacramental. Muslim law sees it as contractual. Christian law is distinctly religious, and the Special Marriage Act is entirely secular. When we look at monogamy, it's strictly mandatory under Hindu, Christian, and secular laws, whereas Muslim personal law permits limited polygamy under specific conditions. And regarding divorce, all the systems now incorporate statutory divorce, but Muslim law also uniquely recognizes talaq. It's a complex system where your exact legal rights and obligations change significantly depending on which column you fall into.
But here is the thing. These disparate systems aren't frozen in time. The landmark case Shira Bano v. Union of India is a perfect example of this. This case profoundly strengthened constitutional scrutiny over personal laws. It signaled a major shift. While religious diversity is absolutely respected, the underlying rules are increasingly being tested against the overarching constitutional values of equality, dignity, and justice.
Finally, Section 4, Beyond Traditional Marriage, the Modern Frontier.
As modern society shifts, the law has to catch up, pushing into the modern frontier of what actually constitutes a recognized relationship. A huge legal development here is the formal recognition of a relationship in the nature of marriage. That is the exact legal phrasing courts use to address live-in relationships, and the definition is highly specific. It requires unmarried adult couples to voluntarily cohabit in a way that truly resembles a marriage. It demands a shared household, stability, and continuity. You can't just be roommates. The relationship has to function like a marriage in everyday life.
And defining this isn't just an academic exercise. It has massive real-world consequences. Under the Protection of Women from Domestic Violence Act of 2005, women who are in a relationship in the nature of marriage are legally protected from abuse and can actually claim maintenance rights. The courts have recognized that family law protections need to extend beyond the strict boundaries of formal marriage certificates to protect vulnerable people in non-traditional unions.
We're also seeing profound legal evolution regarding the LGBTQ+ community. Let's trace this impartially. Historically, same-sex relationships were explicitly criminalized under Section 377 of the Indian Penal Code. Then we saw a massive constitutional shift with the Navtesh Singh Johar case, where the Supreme Court firmly decriminalized consensual same-sex relations, grounding that decision in individual privacy and dignity. And most recently, the Supriyo v. Union of India case brought the specific debate over the legal recognition of same-sex marriage directly to the nation's highest court.
So where exactly does the law stand today? Well, the crucial factual point is this. While same-sex relationships are completely decriminalized and formally recognized under the umbrella of privacy and dignity, same-sex marriage itself is not yet fully recognized legislatively under India's marriage acts. That's exactly where the legal status rests right now. Decriminalized, but awaiting legislative action for formal matrimonial recognition.
Which leaves us with a pretty fascinating question to consider. As the courts lean more and more into constitutional values like dignity, privacy, and individual autonomy, how will India's complex matrimonial mosaic continue to adapt? We started with strict religious rules, moved to secular choices, and now we're seeing the very definition of partnership being redefined. How this massive library of rulebooks evolves to reflect the changing face of modern relationships is something we'll all be watching closely. Thank you for joining me for this explainer, and keep questioning the structures around you.